Hi everyone, and welcome back to Flow Migration Law. I'm Jay, your principal migration lawyer. What if a decision you made with the best intentions, a plan that seemed perfectly logical, actually put your entire future with your partner in Australia at risk? Today, I want to walk you through a real client story that highlights a little known but significant challenge called Schedule 3. The journey shows how easily you can face a major problem without even knowing it, and how we navigated through it. Let me introduce you to the couple. The applicant first arrived in Australia on a working holiday visa, subclass 417. During his time here, he met his partner, an Australian citizen, and they built a committed 2-year relationship. As they planned their future, they decided the best way for him to remain in Australia was to apply for an onshore student visa to pursue his passion for IT. This felt like a smart, forward-thinking plan. While that student visa was being processed, he was granted a bridging visa A, keeping him lawfully in Australia. Feeling proactive, the couple then lodged their onshore partner visa, the subclass 820. They believed they were doing everything right. But months later, they received a letter from the department asking them to satisfy Schedule 3 criteria. They had never heard of it, and a quick search online filled them with panic. They realized they had unknowingly triggered a complex part of migration law that carries a very high risk of refusal. So how did this happen? The problem wasn't their relationship, it was a matter of timing. Now, when they applied for their partner visa, the applicant was holding a bridging visa A. Now, it's crucial to understand that a bridging visa is not a substantive visa like a student or work visa. Under the Australian migration law, applying for a partner visa onshore while holding this type of bridging visa automatically engages Schedule 3. Now, to get the visa, they had to prove more than just their relationship. They had to persuade the department that there were compelling and compassionate reasons to waive these extra criteria, a very high standard that is not granted lightly. Our first step was to build a comprehensive submission that addressed the waiver requirements head-on. We had to paint a detailed picture of their lives and demonstrate why forcing the applicant to leave Australia would result in serious and damaging consequences for his Australian citizen partner. Our legal submission detailed 3 key areas. First, the nature of their relationship. We went beyond the basics to show the profound level of interdependence they had. Second, the circumstances of the application. We explained the context of why they applied when they did, showing it was a result of a genuine, albeit legally uninformed, desire to secure their future together. And third, most importantly, the compelling factors. We carefully documented the significant emotional, financial, and practical impact that a separation would have on the Australian partner through a variety of their personalised factors based on their unique circumstances. We were to present a case that was not just about a relationship, but about 2 lives that were completely intertwined, supported by extensive evidence. The result of this methodical and well-prepared response was a complete success. The department accepted our submissions. The Schedule 3 criteria were waived, and the visa was granted without any further requests. The couple could finally breathe a sign of relief and continue with the life they had built together, knowing their future in Australia was secure. This case notes some critical lessons for any visa applicant. 1. Visa timing can be everything. When you apply, it's just as important as what you apply for. 2. A bridging visa is not a simple placeholder. Applying for another visa while holding one must be handled with extra care. And third, I didn't know is not a valid reason. The department expects you to understand the law, and unintentional mistake can still lead to the same difficult legal situation. The reasons for a waiver must be substantially more powerful than simply not knowing the rules. This couple's story had a happy ending, but it's a crucial reminder that preparing an application is not just about filling in forms, it's about navigating a legal framework. If you're planning your partner visa journey and have a complex visa history, or think you might have a Schedule 3 issue, it's highly advisable to seek legal advice early. A professional can help you understand your position and prepare a detailed submission before a problem arises. You can book a free discovery call with our team via the link in the description. If this video was helpful, please give it a thumbs up and subscribe for more real-life case studies. Thank you for watching.